Well, the federal election interference case against former President Donald Trump is formally back in the hands of the U.S. District Judge overseeing the trial, and she is ready to proceed. Over the weekend, Judge Tanya Chutkan swept aside two of Donald Trump's attempts to dismiss his Washington, D.C. criminal case. She also set a new hearing date and deadlines to get this case back on track after an 8-month pause to resolve the dispute over presidential immunity. Let's bring in an SNBC legal analyst and criminal defense attorney, Danny Cevallos. So, Danny, Judge Chutkan set August 16th for a hearing in this case. What can we expect at that hearing? Will we get a trial date?
Boy, it's going to be a complicated thing for Judge Chutkan to figure out how to take the Supreme Court's decision in the immunity case and make that into an actual thing where she takes in evidence and decides to what degree there's going to be immunity. So much of this is not fleshed out yet. We may get a trial date. We may not. We are on a new frontier here. I mean, no other court has ever dealt with implicating what the Supreme Court has told the lower court to do in terms of immunity. And the motion that she just denied was related to selective prosecution, not really related to immunity at all, but they put it on the record. They preserved it. It's really the immunity question that may leave very little of this case left after Judge Chutkan is finished with her hearings.
Yeah, so give us more about that because of the presidential immunity decision. Will we see this case narrowed? Will the charges against Trump potentially change?
Well, here's a possibility. It may not change at all. Maybe Judge Chutkan gets it, holds hearings, hears evidence, and says, no, all of this was completely unrelated to official presidential conduct. That is theoretically a possibility. Far more likely, given the Supreme Court's order and directive, is not only that core presidential powers are absolutely immune, even broader are two additional things that don't get as much attention. Number one, the presumption of immunity. So anytime Trump says, hey, this is in that gray area of official conduct, he gets the presumption of immunity, and the government has to overcome that presumption. Presumptions in the law are a very powerful thing. The presumption of innocence, for example. I've had many cases where I don't have a lot of good evidence on my side, and the only thing the criminal defense attorney can do is pound the podium and say, well, there's a presumption of innocence. That's how powerful presumptions are. The other thing, too, is the thorny issue of evidence. The Supreme Court has said that you cannot use these official acts even as evidence against the former president. What is that going to look like? That's another thing Judge Chutkan has to deal with. How does she hear evidence if it's not admissible? It's very unusual for the Supreme Court to rule in on the admissibility of evidence. We have rules of evidence, so it's very fascinating to see how Judge Chutkan is going to actually do this. And maybe it doesn't matter because whatever the outcome, Trump will appeal, maybe right back at the Supreme Court anyway.
And we've got about 30 seconds left, but I understand there was an update involving the gag order in Trump's hush money case. What can you tell us?
This is fascinating. The state of Missouri sued the state of New York, asking for, in the Supreme Court, claiming original jurisdiction. There are some cases involving states versus states that you can file directly, in theory, in the Supreme Court. But the Supreme Court rejected this effort, rejected this motion. They wanted a stay of the gag order and sentencing, arguing that the gag order, still in effect on Trump, was impeding on the rights of Missourians, I think that is, Missourians who are wanting to vote and get all the information they want about the former president. So in other words, the gag order prevents them from being able to vote properly. I mean, that's really it in a nutshell. It's a very curious theory. It's interesting from an academic perspective, but it was never really likely to succeed because...
And the Supreme Court said, no.
The Supreme Court said...
Not going to take this one.
Yes, in a very short order. But the other thing is that if it were to go forward, it's a scary thing to think that states could just start suing each other if they don't like the outcome of a criminal case in that state. So probably the right result for the country.
Thank you very much, Danny Cevallos.